So tonight we have a special guest, folks. We have Professor Elizabeth Loftus. She's a world-renowned leading expert on memory. She's best known for her scientific research on the misinformation effect, false memory, and her criticism and critiques of recovered memory therapies. In addition to being a distinguished professor of psychological science, criminology, law and society, cognitive science, and law at the University of California, Irvine School of Law, she's provided expert testimony and consultation for lawyers in over 300 court cases. I hope that number's right. Correct me if it's not. Including legal teams involved in the Maxwell case, Harvey Weinstein, Ted Bundy, O.J. Simpson, Robert Durst. In addition to that, she's written some great books, including The Myth of Repressed Memory, False Memories and Allegations of Sexual Abuse, and Witness for the Defense. Welcome, and thank you for joining us tonight.
Well, thank you for having me.
Joseph, over to you.
So, we're seeing a resurgence, particularly in Canada, of recovered memory and experts testifying about how memory is encoded, and so we're very thankful to have you on. So you had this very interesting model that we were looking at, which speaks about the memory unreliability model, and we'd like to really turn it over to you to talk about the process. Although this is old stuff for you, we'd like to really talk about the process of it, and if you can give us some brief outline of it, then we can delve into some specific areas.
Way early on in my career and involvement in legal cases, I and many others were doing studies of where we tried to simulate what the kind of thing that happens when people might see a crime or an accident and later on have some new information that they're exposed to. They get interrogated or they talk to other witnesses or they see media coverage. And in simulating this kind of situation, we did, now hundreds of experiments in which people see a crime or an accident. Later on, they get some misleading information. And we basically show that misleading information can contaminate or distort somebody's memory. So we can pretty easily make people believe that the car went through a stop sign instead of a yield sign, or that the bad guy was wearing a brown jacket instead of a green jacket, changing the details about an event that actually did happen. And all this work taught us something about the malleable nature of memory. But I can go further if you, or do you want me to stop for a question?
Yeah,
or just keep
going?
I
think we're particularly interested in not just witnessing, but if you are allegedly the complainant or the victim of an alleged abuse, how certain things may impact your perception and ability to recall later on. And for example, if somebody at the time that something happened may be intoxicated or on other illicit substances, and then how that plays out, not just with something which is reported right away, but then when we talk about historical allegations and how the recounting of it can either be influenced or tainted, etc.
Okay, so that early work did show that you could change memory for the details of an event that was actually experienced, but you can also change memory. You can change other kinds of memories by exposing people to negative or biasing information. You can get people to remember things as being, more awful, more inappropriate, less consensual, or all kinds of more negative things. So that work on the malleability of memory does also apply to this other kind of situation where people might have an interaction with someone else, but are then exposed to some new information about that alleged perpetrator that does distort their memory for what they saw. The big controversies, though, in the 90s had to do with the claims of massive repression, where people were claiming that, they were raped, over a period of 5 years and totally repressed the information into the unconscious and then reliably recovered it later. And for that kind of claim, there was, virtually no credible scientific support, despite the fact that we were seeing those kinds of accusations throughout courtrooms all over the world.
Yes. So, you've written in one of your pieces, contrary to what most people believe, memory doesn't work like a video camera, with events perfectly preserved. Inaccuracies creep in through imperfect perception or biased inferences or conflation with details from other events. Can you elaborate on that? Because we face this a lot, where an allegation may come out 2-3 years later or 4 years later. It could be in the context of a bad divorce. It could be in the context of somebody who is in therapy, then starts to look back at a relationship and see it in a different way. And there's a push that we fight, which is the memory is still not tainted, it's accurate, and you remember these things just simply because of the trauma of it, regardless of how small inconsistencies may or may not be relevant. That I get. It's sort of the bigger picture I'm interested in.
Well, I mean, what this work on, mostly what I have studied is post-event suggestion. And post-event suggestion, just to reiterate, not be too redundant, can distort or contaminate or transform somebody's memory. And it can do that by changing memory for the details, but it can also change memory for the way you feel emotionally about the event, or how awful you thought or inappropriate you thought the event was. I've seen this kind of thing happen in many cases. There are other things that also affect memory that many other psychologists have been investigating. This isn't the only problem, but I think this is a major problem when somebody does have some kind of interaction that is somewhat, ambiguous or maybe confusing, but later on it gets labeled as horribly awful. And people, in some way, it gets labeled as horribly awful. Other people come along and say he did something bad to me. These are the kinds of things that can affect how the first person remembers their own past experience.
So, for example, we face a number of cases where something happened. There was a relationship 2 to 3 years before, and then they meet somebody as a therapist for some other issue in their life, and then they start talking about the relationship, and then the therapist, who may not be a psychologist, for example, could be just like a counselor, but they start to talk about how that relationship in fact was unhealthy, that in fact it was abusive of you. That type of intervention through what we call therapy, what would your comment be about it? I know what my comments are about it, but you as the expert, I'd like to have your commentary on that.
Well, that's an example where something gets labeled in a particular way, and then people start to see it more in the direction of that label. So it can be a problem if some therapist comes in and says, I'm telling you that's abusive, or I'm telling you what happened to you is sexual harassment or sexual assault or child sex abuse. It gets labeled that way by, in some cases, an authority figure, which many people believe their therapists are kind of authority figures.
Right.
And it can have the power to contaminate the way people reconstruct the past.
Sounds like a lot of this is language driven, right? The words you choose, the words an interrogator chooses, a therapist chooses.
You can think of it as language related. I mean, I once did a study long ago where we had people refer to an ambiguous incident as an incident versus a fight.
Right.
And that affected the way that, in that particular study, the way mock jurors reconstructed the event when they were trying to make a decision about guilt or innocence. So yeah, certain words are like labels and can label an event in a way that shifts the memory in the direction of that label.
Can you tell us a little bit about your memory unreliability model? We've been studying it quite closely. Looks very interesting. If you could perhaps, we'll later post it on the podcast so people can see it. But I think this was the one you used from the Weinstein trial. the one about acquisition, retention, and recall?
Okay. Well, it's customary for psychologists to divide the memory process into three major stages. So first, there's an acquisition stage. That's a period of time where some event occurs, or sometimes it's a few events. Then time passes, and that we call that the retention stage. And then after a while, somebody tries to recall what happened, or retrieve information from memory, or answer questions, or give a police report, or testify in court. These are acts of retrieval. We call that the retrieval phase. Our job as psychologists who study the memory process is to identify the factors that come into play at each of these stages that affect the accuracy of somebody's memory. So, in eyewitness cases, murder, robberies, and things like that, there often is a lot more attention paid to the acquisition stage, the conditions of the event itself, the crime. How good was the lighting? How far away was the person? Was the person intoxicated or not? In some of these, particularly these delayed memory sex abuse cases, what's probably more important is what's happening during that retention interval. Are they exposed to a suggestive or biased media coverage? Are they exposed to biased interrogations? Are they exposed to information that other people are making complaints? And that new information can enter somebody's memory and cause a contamination and alteration of memory. So now at the time of retrieval, when you try to tell in your own words what happened, or answer questions, or testify in court, you're basically testifying based on a contaminated memory.
So when you've been retained in criminal trials, is your focus as an expert in primarily the retention period in terms of your analysis for defense?
Well, much of the work, the scientific work I've done, is on kind of post-event contamination. So that happens to be a topic that I know exceptionally well and get called to testify about quite a bit. And often that is one of the problems in a particular case. It really depends on what the case is about. If it's a stranger robbery situation, and let's say it's a cross-racial identification where a member of one race has been interacting with a stranger of a different race, then I might talk about what we know about cross-racial identifications, that they're more difficult for people, that people make more mistakes. But if it's not a cross-racial case, then that factor wouldn't play any role at all. This is not, in much of these alleged sex abuse case, this isn't the issue. The identification, usually people are talking about what happened with somebody they know.
Right.
It depends on, what's called for, what's the relevant question in the case. But in the, if you wanted to, I could certainly send you my testimony in Ghislaine Maxwell's trial, for example.
That'd be great.
In that particular case, the judge ruled that I could only testify about the workings of memory. No specifics about the specific people or the specific suggestive things that might have happened to them. No mention of how their testimony changed over the course of time. Only the basics of memory malleability. And that was the judge's decision in that case. In other cases, an expert could go a little further and say, I see some red flags here. That, the story changed from point 1 to point 2. Right. And look what happened in between. There was a massive media coverage. There was a lot of multiple accusers getting together for a joint meeting with the plaintiff's attorney, who's also planning a civil suit. And you can point to some problem aspects of the case for trying to understand whether you're dealing with an authentic memory or one that's a product of some other process. But sometimes judges don't allow that kind of specific testimony.
You know, I'm interested because in Canada we don't do as much publicity with cases as you do in the United States. That said, I've run across a number of complainants. They have particular language in their statements that could only be derived from doing research online, being exposed to social media and posts and other cases where you just know this language is coming from another source. And I cross-examine on that as to what they've been doing and what they've been viewing. But I find particularly in the last 5 years, more than ever, access to all sorts of sources of information, either accurate, not accurate, whatever, has duly impacted the way they come across with their evidence, and frankly, I find taints their memory. And just the prevalence of it now, I think, is a big problem for a number of these sexual abuse cases.
Well, they're getting it not just from the internet, but they're also getting it from their therapist. And they're getting it from what the therapist is saying to them in the therapy sessions, and they're getting it from the books in the incest book industry that they are directed to read or that they find themselves. And that's where they're learning what the kind of, repressed memory aficionados and others believe to be true about memory. And some of those beliefs that are being transmitted to these accusers are not supported by scientific information. And yet they're being embraced by these patients through this therapist and biblio education.
So that's interesting. If I can just reflect on that for another moment, because again, with respect to repressed memory, I mean, where somebody says, for a number of years, I just never remembered this. Regardless of the therapy, I have a challenging time as just a lawyer, not an expert in memory like you, having or placing any reliability in that whatsoever.
Well, I do think we have to stop and realize that sometimes people can have an experience, not think about it for a long time and be reminded of it.
Right.
That happens. That is ordinary forgetting and remembering. But what has been claimed in these claims of massive repression is something that is too extreme to be explained by ordinary forgetting and remembering. I had a case where she remembered her father raped her between the ages of 5 and 16, allegedly repressed this more than a decade of abuse into her unconscious until she went into therapy when she was 18 or 19. This is kind of too extreme to be explained by ordinary forgetting and remembering. And in a way, it's not always easy to tell the difference between what's ordinary forgetting and remembering and what is something that's just too extreme and for which there's no evidence.
Right.
You kind of know it when you see it, but still, some of these claims that were so prevalent in the 90s, and even later, are pretty bizarre. And I basically would just want to say to the prosecution expert, just show me the proof that somebody can be raped for a decade and be completely unaware that this even happened to them. Just show me. And then maybe I'll change my mind.
Have you seen of any type of studies to deal with, post-case, to try and tease out what factors they're relying on? There's no studies that I've read.
Well, and these repression aficionados will come in with a pile of studies. They'll say, I know of 70 studies that support the idea of massive repression. And in fact, I'm teaching many of them right now in my graduate seminar at the University of California, Irvine. And it doesn't take very long for my students to see these don't prove repressed memory at all.
Well, those articles I refer to as generally junk science. I mean, I've read a lot of those, but anything with any type of validity that you've run across?
I mean, it's interesting you call them junk science because some of them get published in peer-reviewed journals that where the editor and the editorial board are all people who believe in this theory and just love to accept articles that promote the theory. I mean, that's why, the prongs of Daubert are a little bit difficult here. I mean, is it published in a peer-reviewed journal? People are creating the appearance of a peer-reviewed journal, and it's very hard for say lay triers of fact to know why this journal is kind of a legitimate one and this one maybe not so much.
Big conundrum for jurors.
Well, and the judges who are the gatekeepers.
Right. Tell us a little bit about our viewers would probably be very interested to hear a little snapshot of your involvement in a trial, for example, perhaps the Ted Bundy trial, how your expertise was used there.
Well, Ted Bundy, I mean, that was very, very early on in my career. And when I got a call from Ted Bundy's attorney back in 1976, he was representing a first-year law student at the University of Utah Law School, a man who was accused of an aggravated kidnapping and was identified about 9 months later under some, questionable circumstances about the way that identification was conducted. So we didn't really know he would become the Ted Bundy.
Right.
He was a first-year law student, and he got caught up in this accusation with some issues about the identification. It turned out I did testify in that case. He was convicted. It was a bench trial, by the way. His attorney chose to waive the jury, and he was convicted, and then he would be extradited to stand trial for something else in another state, eventually end up in the state of Florida, and eventually it became this prolific serial killer that and was executed. So, but way back then, in the very beginning, he was just a first-year law student.
But what interested me was your analysis of the I think it was Darange was the witness, where you kind of took them through the initial description to the police, her later recollection, and how her confidence increased over time, as after all the police handling she had experienced.
Well, that's another problem I see in a lot of cases. You're asking me about a really old case. You're asking me about
there's a memory test.
Maybe my 10th case, and now we're up to over 300 trials since the 70s. So
it's an oldie but goodie.
Specific details of that one I may be a little rusty about, but in general, what happens that it can be a problem is that through interactions with a witness, you can artificially increase their confidence level. When somebody goes to a lineup and says, I'm pretty sure, I think possibly this guy, and the officer says, good job, or that's who we think it is, that's our suspect. By the way, we think we found a fingerprint of his. It's going to artificially inflate the confidence of the eyewitness, or victim, making that person more confident, more impervious to cross-examination, more influential to the jury, and a problem for a defendant and a defense lawyer.
Well, feel free to fast forward to a more recent case if you want to share one that you found particularly interesting.
Oh, no, well, you can ask. No, I'll try to anything you want here. I mean,
Joe?
Well, the Harvey Weinstein case comes to mind because, of course, it's very notorious. But what was your role there with memory?
Okay, there's a difficult one because I'll tell you my role in that case. I got a call a few years ago now, when Harvey Weinstein was first accused, from a lawyer in Los Angeles who was representing him in some potential California accusations. This was a woman attorney who I had worked with before, really smart, really good. And it is a big pleasure to work with somebody who's smart and good and prepared and so on. So, I kind of looked forward to the chance to work with her again on another case. So nothing was really materializing in the Weinstein Los Angeles matter. But over the next year or more, it did materialize with some New York accusations. By this time, I had been exposed to a lot of media coverage myself about Weinstein. And when they wanted me to step in the New York case, I was, not so sure I wanted to do it because, he was just painted to be such a bad person. So I solved this dilemma for myself by recommending another expert. I had a perfect other expert for Harvey Weinstein to hire. She not only could cover the memory issues, but she had a broader expertise than mine. She studied sexual communication, sexual consent. Well, they met her, they liked her, they hired her, and I thought, okay, I'm off the hook. I don't have to worry about this. But Harvey talked to somebody who said, if on the memory issue, really, you need to talk to Elizabeth Loftus, and so Harvey and his lawyers went to the judge and said, we want Loftus too. And surprisingly, I thought possibly the judge would find it a little duplicative, but the judge admitted my testimony. And now if I was not going to do it, I was going to have to withdraw. And then I just said to myself, why are you withdrawing? And I'd be withdrawing because I'd been seduced by the media, which I'd been warning people about for years. Don't let this happen. I'd be withdrawing because I was selfishly worrying about how it would affect me and my ability to help other people in the future. I'd always be linked to this. I was going to feel like a coward if I withdrew. And so I said, okay, I'll do it. And I went to New York, testified again, one of those teaching testimony types of material, just about the science of memory. And, a lot of, well, of course, he was convicted of some of the allegations and not convicted of others. To, I guess, his and his attorney's surprise, he was given a very harsh sentence for the particular crimes that he was convicted of. So that was my experience with Harvey Weinstein.
Yeah, I found it interesting.
Just because he, I sort of want the world to know, just because he did some bad things, it doesn't mean he did every bad thing that he was being accused of.
Well, that's right. And I also found it interesting as you talk about it, because the publicity out there was so staggering that by the time you come to trial, very challenging for a fair trial to get an impartial hearing. But then also it even had an impact on you as a witness, as an expert witness. So, those are the dangers. Yeah. Those are the dangers of that type of pretrial exposure on a file.
Well, let me bring up another subject with you that I wonder if you two have thought about this and whether it's an issue in Canada. But the issue has to do in these sexual assault and sexual abuse cases, the admissibility of what you might call Me Too witnesses. Completely right. Different people who say this guy did something to me too. They aren't part of the prosecution. They aren't part of they aren't a plaintiff in the civil action. They're just people brought in by the prosecution or the plaintiff to say he did something like this to me too. I mean, I'll give you one example with our former president. And however you might feel about him, he's being charged in a civil case with raping someone in the Bergdorf Goodman department store. And in the civil case, they're allowed to bring in somebody who says he once groped me on an airplane. Different person, different decade, different incident, not part of this case. And he's also, the plaintiff also brings in somebody who says in a different decade, a different location in Mar-a-Lago, I was a journalist, he was giving me a tour of Mar-a-Lago, and he planted a big, wet, sloppy kiss on me or something like that. So what is the effect of these Me Too or propensity witnesses, and is it fair? And, for people who don't like Donald Trump, they say, well, maybe he deserved what he got. But my reaction to this is, if they can do it to somebody who may be unpopular to you, they can do it to somebody who's popular, and they can do it to somebody who's innocent of the thing they're being charged with. And this is something that's actually been on my mind lately. Is this fair?
No. There's a little more leeway in the United States for calling that evidence. We have it as similar fact evidence in Canada, but it has to be very similar evidence to be allowed in. And there has to be not only, to some extent, a temporal connection, but there has to be really a nexus with respect to the allegations. That's done in such a way that it has a striking similarity, that it would go to a modus operandi, and therefore has some value as supportive evidence of the complainant herself. So we have pretty good, strict guidelines on it, but it still can be very dangerous and can lead to a wrongful conviction. And in the United States, if you're calling people with very dissimilar allegations spread out, all across time, it's really just propensity reasoning. And in the civil context, it's even more loose than in the criminal, but very, very damaging. And everybody, like you said, should be aware, if they can do that to somebody who's unpopular and maybe well known as a celebrity, it can certainly happen to somebody who's marginalized and innocent.
Absolutely.
I think we think of these things a lot. It's our business, but I think we're running out of time now. But I can't thank you enough for coming on. Your work has been really inspiring, something we read very carefully and we follow. And we can't thank you enough for not only your hard work and your courage in doing what you do, but thank you for coming on this podcast.
Thanks very much.
My pleasure. This went by so fast.
I know. We'll have to have you back.
Well, you're more than welcome to come back. And if you could send us your testimony, that would be. We'd like to go through it and maybe at some point invite you back.
I could send you the actual testimony in let's say Maxwell or Weinstein if you want to read it.
Great.
That would be wonderful. Thank you very much. I do.
Happy to.
Thank you so much. Well, it's a pleasure meeting you.
Thanks.
Virtually. Take care and have a lovely day.
Okay. Bye-bye.
Bye-bye. Well, that was great.
That was, wow.
When you look at that model, I just want to talk about it for a moment. But in one of her articles,
here it is.
How the Truth Gets Twisted, which was a 2012 publication, written by Elizabeth Loftus. She says things which run contrary to what certain interest groups want to say are true. But I found it very compelling when she wrote, "Contrary to what most people believe, memory doesn't work like a video camera.
Oh yeah.
With events perfectly preserved. Inaccuracies creep in through imperfect perception or biased inferences or conflation with details from others. Without independent corroboration, we can't really know for sure if a memory is true or not. Usually it doesn't really matter much, but in the circumstances where there is liberty at its stake, it really does matter.
Like a criminal trial.
Yeah, and in Canada, there does not need to be corroboration, but you're left with a complainant's evidence, maybe going back 3 years, 4 years, 5 years.
Right.
But, in this model, there's good points. And we have arguments in cases where, the acquisition period of memory is extremely important. You talk about drugs, alcohol, circumstances, emotions, and arousal. And many will, I have a case that almost got to trial, but it got adjourned, where we were dealing with a complainant who was intoxicated every day on alcohol, using cocaine, crack cocaine, and sometimes heroin, and would want to say that there's gaps in my memory, but what I do remember is
recall is accurate. Yeah.
And then over the retention period and the recall, which was particularly important, was she was exposed to a counselor who was telling her negative things about my client, for which I was going to go after in cross-examination, or if it does go to trial, I will. I'm trying to convince.
Well, reaffirming the negative, external validation.
But it's extremely pernicious.
Oh, of course it is.
And, she talks about this, and this we'll have to put up because it's extremely important. But there, in therapy, and it seems to be rampant, that there is this tainting which can, turn a situation, what we call relabeling, from something that may have been innocuous or not so bad or a positive relationship into something which is quite negative and result in charges. So this is such great work that she does.
It's huge. And we also have to pay attention to the language being used by the police. I wish we had access to VWAP, somehow get disclosure of any contact the complainant's had with.
I'm less worried about the police interviews because they're on video.
They're on video, but VWAP?
And a lot of the time, I've watched police officers just let it roll. Like, they talk.
Right.
And once they got the story out, then they go back. So I think I've seen, some very good interviews with trying hard not to. But you talk about VWAP, what that is, and what other communications. So just explain that. Again, we've talked about them before.
So typically complainants have access to the Victim Witness Assistance Program. It's meant to be a support program that guides them through the process, what's next. If they want to have contact with the court or the Crown, typically it goes through them. But muddled in the middle of all of that is support, whatever that looks like, and whatever language might be used there.
And so I've met some workers who are very good and careful, very careful, like just directing to resources, passing on information, being very helpful in that regard. But we run into others where there is a real
agenda,
and unfortunately they are unduly influenced by it, and it becomes a problem. And then frankly, we can find that complainants over time become overly invested and entrenched in their allegations, such that they will not come off of what are unreasonable assertions that they make. Who knows what other influence there is from counselors or therapists or people or even family members.
Family members, come on, we see it all the time with relatives influencing young children or parent against parent.
And let's just say one other thing that she raised, which was good. So in the United States, when she was testifying, in the Maxwell case, she was limited to basically the science of how memory works. That would be very typical in Canada too, because in Canada we have a rule that you can't give evidence, an expert can't give evidence on what's the ultimate issue. So for a witness to then go through an interview or other sources and say, these would be red flags, this would negatively or unreliably impact their evidence, would be quite unusual in Canada. But you can imagine sometimes calling an expert and putting hypotheticals to say, based upon your scientific work, if somebody were to be exposed to a type of therapy which would essentially give negative impressions of the accused, would that have an impact? Well, from our scientific work and our studies, it absolutely would. I don't think I think it would be very difficult. We've had some of that evidence in the past. I think Dr. Moore's testified about in child-related cases, but we haven't done a good job of opening that up.
No, we have to push that farther.
And then the Crown uses their experts about memory and how trauma affects memory, and therefore if there's inconsistencies, you really shouldn't worry about that because it's just trauma. Whereas, when we talk about this, it's so important that doesn't excuse it. That makes it more unreliable.
Exactly.
Well, it's going to be. She promised to send us those transcripts.
Yeah, I'll follow that
up. It's U.S., but I think I'd like to read both of them.
They'll be valuable
and related and see.
And then I got to get her back for part 2.
And let me just explain. You're in a suit.
Yes.
Very nicely dressed, and I'm very casual. I spent the day at a jail meeting a client.
I ultimately got him bail, though, so he got released.
So I commend you on. I should have been in a suit for this interview, but I was doing some important and difficult work today.
She stayed on, so she'll be back. I'll get her back.
This is great. So thank you everybody for watching. We have the pillows.
Where's your pillow? Please.
Don't forget to like, comment,
subscribe, and share.
And again, we've got great comments coming in, emails. Many of our viewers are corresponding with us on a regular basis, and that's great because it just enhances what we want to produce for you to read, which we send out over email, and in what you view and listen to here on the podcast. So thank you very much. And
let us know the type of experts you'd like to hear from, such as the one we just had tonight.
Yeah, we're trying to bring on more to broaden the discussion and broaden the knowledge base for all of our viewers. So thank you. Have a good night and stay well.
Bye-bye.